I really appreciate you being here, and I appreciate the opportunity to talk about the importance of professionalism in the face of the incredible changes that our practice of law is undergoing. We talked about, over the last couple of days, data management, knowledge management, brand management. We have big data, deep data, dark data, virtual assistants, intake specialists who turn every click or call into a paying customer. So I'm wondering, really and truly, do we have a profession or do we just have a business of law? How many people say law is a business? Law is a business, okay? How many people say law is a profession? Okay, some of you, I noticed, said both. And that is, from my perspective, where we are at. We cannot ignore the fact that there is a lot to be said for the business of practicing law. I travel the state of Illinois as the executive director of the Illinois Supreme Court Commission of Professionalism, talk to tons of lawyers. I am also the chair of the Standing Committee on Professionalism for the American Bar Association. I promote professionalism with groups of lawyers both in the state and across the country. And for those lawyers of a certain age, like my age and older, I hear very often that the business is ruining the profession of law. It used to be a collegial profession where there was time for reflection and interaction with like-minded colleagues, but now it's just a business. I come at it from a different perspective. If being businesslike means that we take the very best tools that we have at our fingertips and apply them to better serve our clients, then being businesslike means we're being more professional. If, on the other hand, being businesslike means we are merely motivated by profit without a regard for service, pro bono, helping the public, and the other aspirational, ethical, and professionalism principles that guide our profession, then being more businesslike undermines professionalism. I spent a lot of time in the preamble to the rules of professional conduct because that is where the aspirational goals of our profession are located. And in the preamble is described 3 separate sets of responsibilities we have as lawyers. We are representative of our clients, of course. We counsel, we advocate for them, we represent clients. But there's 2 other sets of responsibilities that lawyers have. We are officers of the legal system. Used to be said officers of the court, but that was changed some time ago to make clear that whether we practice litigation in court or not, we represent the system of justice, and we have an obligation to the legal system. And the 3rd set of responsibilities is, as a public citizen, with a special responsibility for the quality of justice. We often don't think about those other 2 legs to the stool, I like to think of responsibilities that lawyers have. But I think particularly in light of the technological and globalization changes affecting our profession, it's very, very important to remind ourselves of that. So today, this presentation is going to provide a quick overview of some of the changes that are affecting our practice. And of course, you guys are very well versed in those changes. And then I'm going to draw your attention to some key ethical rules that are implicated by the changes. And last, we're going to explore together some of the professionalism principles that it's important for us to remember if we're going to maintain ourselves as a profession and not just be a business purveyor of legal services. We used to have a monopoly on information as lawyers. How many of you, did any of you, begin practicing law before there was the internet? All right. That was my reality as well. And in reflecting back as my early years as a practicing lawyer, I think my value add was we knew how to access that arcane Keynote West system. We knew, right, how to shepherdize cases, starting with the biggest tomes, going down till you got to the pocket part, to ascertain, was it good law, was it cited, was it overturned? Nobody else knew how to do that. So access to information, our monopoly on that, was a huge part of what we brought to the table as lawyers. And then as we became more experienced, of course, came what do you do with the information? How do we apply it to our clients, etc. But we've been struggling since the internet came here to figure out how do we define our value add? Because the reality is, why would anyone pay us for what they can get for free on the internet? And as I traveled the state and the country, lawyers are slowly, not this conference, but some of the other more rural areas in particular, coming to the conclusion that they're not going to continue to pay us. So we're in the midst of an evolution. None of us here are surprised by that. This is based on Richard Suskind's model of the evolution from bespoke or uniquely tailored legal services to become more commoditized. Jack talked about commoditization yesterday in the keynote. It's been picked up by many speakers. Commoditization is affecting the legal field, but other fields as well. Other things that are affecting the practice of law are down in the horizon, and Patrick talked about this earlier at a fireside chat. We're going to have reduced numbers of lawyers. What? Reduced numbers of lawyers? We have too many lawyers, many people say. Currently, we have an oversupply of lawyers. They're carrying a lot of debt. 50% of our law grads cannot get full-time jobs as lawyers unless they are getting hired by their law schools and what have you. At the same time, the applicants to law schools are dropping. And that's going to catch up to us. We're studying it very carefully in the state of Illinois, otherwise in about 2018. So we are going to be looking at a reduced number of lawyers on the horizon. At the same time, there is a widening access to justice gap. And I know that's been discussed in several of the sessions today. Somewhere from 75 to 85% of the citizens in our country do not have access to civil legal services. So, gosh, there's an oversupply of lawyers, there's people who need services, why can't we just match them up? That's not possible for a number of reasons. First of all, many people don't know how to get a lawyer, they don't know that they have a legal problem, and they are sure even if they could find a lawyer, they couldn't pay them. In addition, the oversupply of lawyers who are carrying a massive amount of debt means they can't afford to render services unless they get a certain amount back. So this is a problem for our profession because, again, we have an obligation not just to make a living and to serve one client, but to serve society in a broader sense. I'm going to touch briefly on several models that are out there attempting to bridge this justice gap. The first one was the subject of a fireside chat earlier today. How many were at the LLLP? So it'll be a little bit repetitive for some of you, but here's where the legal profession, and particularly the Supreme Court of Washington State and the Bar Association, has taken a leadership role in trying to bridge the justice gap. So what is an LLLT? A limited licensed legal technician. After over a decade, maybe 15 years of studying the civil needs of the state of Washington, the court finally adopted in June of 2012 a new category of legal professional. It's not a lawyer, and it's not a paralegal, it's a paraprofessional licensed for certain limited legal activities. To those who are proponents, the LLLT is to the legal profession what the nurse practitioner is to the medical profession. We wouldn't want to go or expect to go to an MD to get blood drawn or a tetanus shot or what have you. We certainly wouldn't want to pay full freight for that office visit. So this is a way that somebody can render certain services without the clients paying the amount that full-fledged lawyers need to charge. So there's two rationales for this new category of paraprofessional: to meet the legal needs of the public, but also in recognition that there are a lot of online and other legal services being offered out there that are completely unregulated. And as a self-regulated profession, the lawyers and the justice system needs to assure that there's some quality in that. There are educational requirements that are fairly strict. In addition to the core classes and the practice requirements, in order to become licensed as an LLT, you have to have 3,000 hours of practice under the supervision of a lawyer. So far, the only practice area that they're allowed to practice in is family law, but that may change in the future. They have to abide by the ethical rules that lawyers have to abide by generally. Actually, some of them are more strict. They may not enter into business transactions with clients at all. As you probably know, lawyers have that ability under certain circumstances. What is revolutionary about this, if that weren't enough, is the fact that the Washington Supreme Court passed an ethical rule, 5.9, allowing these licensed legal technicians to share fees with lawyers. Despite Rule 5.4, which prohibits lawyers and non-lawyers, as we call them, from sharing fees, if they're in the same firm in Washington State, they may share fees. They may be part of the governance structure as long as they are not majority. So this is the first chink in the armor, possibly. Who knows where it's going to go from here? But this is what is going on in England and has in Australia and other foreign countries for some time. The first class graduated, and several have passed the exam and are in practice. The second class graduated just in September. 15 took the exam. I heard that 10 have passed, and there's a full third class going on right now. So where that goes in from Washington State, we don't know. We do know that California and Oregon have task forces that are looking at this option. The Oregon task force recommended that LLTs be pursued, and they said, we recognize there's an oversupply of lawyers. However, there are 86% of the family law litigants in our state courts self-represented. 86% don't have lawyers and are going it alone, and that hasn't changed over time. So we can only conclude, said the task force report, that lawyers have not found a way to meet this segment of the population's need. And they expressed a concern that if the court didn't act, the legislature would. So lest you think it's only a wacky West Coast thing, Minnesota is looking at it, and various other states are also taking a serious look at this model with the primary focus of access to justice. Another phenomenon that's going on, and we've heard of it, you know about it, is, hey, free is better than perfect. I'm not going to pay a lawyer. I can get what I need on the internet. It's good enough. That is more and more that do-it-yourself ethic is promulgating. It's particularly embraced by the millennials and Gen Xers. By the way, the millennials this year will surpass baby boomers in the workplace. So this is only going to increase. Internet legal providers, they're not going anywhere. Particularly in the rural and smaller communities I travel to, there seems to be a tendency in the general bar to say, why doesn't the state Supreme Court just shut down these guys? You know, they shouldn't be allowed to compete against them. You heard from LegalZoom and others, they're going strong, they're meeting a client need. Here are just some of our non-lawyer competitors working in the legal space, making money, and delivering services. Revorce and Modria are in the dispute resolution business. And they're cyber settled. There's a whole bunch of them where they're using algorithms and technology to resolve disputes. And when I report to the state Supreme Courts and to the other justices, I'm saying a lot of people find the court system not meeting their needs and becoming irrelevant. The CEO of Modria, Colin Rule, spoke out at the Stanford conference, and he was explaining that 50% of their online disputes are resolved amicably and 90% without ever involving a person. So these are some of the changes. So where does that leave us as a profession? We have two considerations. We have the ethical rules that we must abide by, right? Those are what we have to abide by if we don't want to get hauled in front of the Bar Council in our state and get our law license suspended or taken away. That is the floor of acceptable conduct. But how many of you would say, hey, if I didn't get called before the ARDC, I am the epitome of professional? No. There clearly are standards and aspirations above the floor that we call the principles of professionalism. That's what sets us apart as a profession rather than merely a provider of certain products or services. So, what are some of the ethical rules we need to be aware of in the face of a lot of these changes that are being discussed at this conference and otherwise? The ABA came out with a new comment to the model rule describing and defining what it is to be a competent lawyer 2 years ago. Most of the states follow the ABA. Illinois finally just last week adopted this comment. And it makes it clear that an element of competency is maintaining the requisite knowledge and skill and keeping abreast of the changes, both in the substantive law and in the practice of law, including the benefits and risks associated with technology. The first 5 years or so, I worked at the Commission on Professionalism. I'd go around the state and people would say, you know what? I'm scared about that. I barely have a computer. I'm going to practice law the way I always have with my legal pad and pen. Now it's clear you can't do that and maintain a law license. When I worked for the ARDC, failure to communicate with the client is your number one ethical problem where people get in trouble. This has become more complicated and more important as the complexities of our practice require us to communicate more with our clients. And if you've looked at the changes to the comments, you can see a trend. The trend is involve the client in the decision-making, collaborate with other lawyers and legal assistance organizations that are providing services. So this communication is extremely important. Perhaps as important are the changes to Rule 1.6 and the urgency that we keep our clients' information confidential. A couple of years ago, this rule was changed, and we used to think of it as we only had to guard the confidential information of our clients. In fact, the rule is much broader than that, and we are obligated to keep confidential information relating to the representation. Not only that, we are obligated to guard against the inadvertent and unauthorized disclosure of information concerning our client's representation. So we can't just say, some IT company is handling that. We need to take reasonable steps to make sure that this information is kept confidential. And the comments to this rule lay out what are the factors in determining the reasonable steps. And it boils down to what is the nature of the information, how expensive would it have been to safeguard it, what did the client say about it, etc. It's all laid out in the rules. And so this makes it clear that we have an ethical obligation that is heightened with the generation of so much more information. Rule 5.3 was also changed recently. It used to say responsibilities regarding non-lawyer assistants, TS at the end, instead of CE. And it kind of implied it was paralegals or people that the lawyer employed. And now it's clear that we're talking about, in this rule, organizations as well. This rule says if you're a partner in a law firm, you have to have in place measures to make sure that non-lawyers who are working on your matters also abide by the lawyer's professional rules of conduct. And if you're a supervisor and you're directly supervising a non-lawyer assistance company, organization, person, you need to make sure that they also abide by the rules. We can't do through others who are not licensed anything we couldn't do ourselves. It's a pretty big responsibility. It will subject us to discipline if we don't follow it. The ethics of obtaining clients via the internet are extremely complicated. The rules, in my personal opinion, are entirely outmoded and ineffective. They desperately need to be updated, personal opinion there. The advertising rules are 7.1 and the several that follow. And generally, Rule 7.1 says you can't advertise in a misleading way. And some of the other rules go on to say you can't solicit somebody, you can't directly ask for their business unless they're a family member, they're a lawyer, or you have a prior relationship. All of this is designed, the rationale was, when the rule was put into place, that a lawyer not overpower somebody who's in crisis, who can't think clearly, doesn't know if they want to employ a lawyer or not. But the reality is those rules don't work in this day and age. The rules that say you have to put advertising material on an envelope or put it at the beginning and the end of an electronic communication, how does that apply to a 140-character tweet? It's hopelessly out of date. And you should know, though, that the ABA in April, the Association of Professional Responsibility Lawyers, are looking at streamlining that rule and trying to make it applicable nationally so that Florida's application of ethics doesn't conflict horribly with most of the rest of the country and what have you. The splitting fees with non-lawyers, I just briefly touch on. You need to be careful that you aren't being compensated or paying someone to advertise you by sharing your fees. Rule 5.5 is also one that is under siege. As you all know, you're not allowed to practice law in a jurisdiction that you're not licensed. But in this age of the internet, how does that all transpire? It's very, very difficult. You need to look at the ethics opinions of your individual jurisdictions. I believe that once New York very recently announced that it is going to adopt the uniform bar exam effective July of 2016, we are moving now more solidly toward a uniform bar exam where once you're licensed in one uniform bar state, you can practice in any other. If that spreads, New York is the first one. That's a pretty populous lawyer state to adopt the UBE. But if that spreads to other lawyer-heavy states, then the next question I have is, why are we regulating lawyers or disciplining them state by state by state? If we have a national standard for bar entry, it very well may affect regulation as well. So those are some of the ethical rules, which brings us back to, okay, we abide by the ethical rules, we have all these changes, but what is the importance of professionalism in all of this? So I'm going to stop here for a second and do a little exercise. Okay, it's late in the day. I know you're trying to just kind of hang out until it's time to go to the party. But I'm going to ask you in a minute to get up and find a partner and recall in your practice, what is the best day that you had as a practicing lawyer? What was it about what you did that day that caused you to go home and tell your spouse or your family or your roommate, this is why I went to law school. This was the best day. Okay, it'll be really short. You'll stretch your legs, get up now. 1, 2, 3, just 1 minute and then we'll switch. So, who would like to share? Dennis, would you?
Sure.
Nice and loud.
Lady's a refugee. She comes to America. She had a horrible experience in Eastern Europe. Brought her mother, took care of her mother. Mother was on Medicaid. They co-owned a house. She was the only one that made the payments. Mother died. Medicaid wanted to recover against the house, which would cause her to lose the house. Medicaid is still recovering. Long story short, I was able to get the state to go away, so she gets to keep her house.
She got to keep her house.
Yep.
That was a great day because of your connection with that client, right? Did it have anything to do with your document production or your automated bill system?
No.
No. That was my entire point. How many of you had your best day revolve around processes, data, bill collection, word processing, those kinds of things? Okay, thank you. That's the point. Where do we have value add is in the personal connections. And that's also where we get the most reward. That's why we went to law school. So we did learn to think like a lawyer, and I suspect a lot of us enjoy the intellectual challenge of being a lawyer. I'm not saying that's not important. It is important. It is necessary, but it is not sufficient, right? It is not sufficient. And thinking like a lawyer only has been problematic in many, many ways. We tend to want to impress one another with our legal acumen or our thoroughness in discovery or whatever. It also has led to overaggression and incivility, which is something that I fight against quite a bit. What we need to learn to do is to think like a client. The client might not want, as John Sell was saying, us to give every reason why we come to our recommendation. They might just want a down and dirty memo saying, yeah, I think you should do this, or do that, or whatever. So we need to think more like a client, and I think it will result in more rewarding practice as well. So the Illinois Supreme Court started the Commission on Professionalism in part to address incivility and over-aggressiveness. In 2007, we did a statewide survey. It was repeated in 2014, last year. Although generally speaking, and this one was electronic, in 2007 it was, fill in the blank in pieces of paper. It's crazy how much it changed in 7 years. But in any event, you can see on the slide, 91% of the lawyers describe their colleagues as generally civil or professional, or very civil or professional. But incidents of bad behavior were not uncommon. 85% said they experienced uncivil or unprofessional behavior. Not exactly serving our clients. So once they answered that they had experienced unprofessional behavior, they were asked to indicate what types of behaviors that they experienced. And they generally fell into 3 categories: prejudice, rudeness, and strategic incivility. Prejudice is ageism, racism, sexism. 9% reported that. Rudeness, 38% reported rudeness. The top category of misbehavior, if you will, in this category was sarcasm or exhibiting a condescending attitude. Ever have that happen? Strategic incivility, the number's not reflected there, but 51% of the respondents reported behaviors that fell into this category. That's a category we kind of made up because it describes why as well as what was being done. Strategic incivility is when I decide, as a matter of strategy, usually in litigation, but not always, in order to gain an upper hand, to bully or be uncivil in some way. The top category of strategic incivility is misrepresenting the facts. And this is really undermining the basic principles of our profession. And it's problematic. It's what happens when we focus on what we are doing as lawyers vis-a-vis one another, instead of our service to clients. The consequences of this are not inconsequential. 94% readily admitted that incivility and unprofessional behavior made it more difficult to resolve our clients' matters. It harmed the public confidence in the judicial system. 91% of us admit that, and it's costing our clients more money, 89%. I want to stop for a second on the makes the practice of law less satisfying number, 92%. I think for many lawyers, myself included, that sniping and bickering and aggressiveness for no apparent reason really undermines our feeling, like Dennis was telling us, when we can really help our clients. I know that when I started practicing in the 80s, I was often the only woman in the room. I put on my armor and I was aggressive. I swore, I smoked, I rubbed elbows up with them, and I didn't feel genuine. And that wears time after time, year after year. So that's part of the reason I got out of litigation. And I ran into someone who was a young associate in my firm many years ago when I had taken this job. And when I was catching up with her, I told her I had 4 children. And she said, "You have 4 children?" She said, "The way you handled yourself at the law firm, I was sure you would eat any young you had." So I was like, "Really? That's the way you saw me?" I thought I just put that on, in the arena, in the courtroom. But it's not a good thing, and as Gina and others have referenced, it leads to, or it could be related to the fact that lawyers drink too much, suffer from mental illness and substance abuse at a much greater rate than others, and are just not as happy as we could be. And I'm going to move on from discouraging diversity in the legal profession, because I'm going to cover that in just a minute. So some people say technology is the reason for all this incivility, because we're behind our email, we are just dashing it off, we're behind our computers, we're not interacting one-on-one, so technology is the culprit. And I think there's some truth to that. Back in the day when I was dictating letters and it took 4 or 5 days for it to show up on my desk, and I saw what I had dictated in writing, my Italian-Irish hothead had settled down, and most of the time I rewrote that letter before it got sent out. But now we're told that we have to respond to emails within 24 hours. So there is some truth to the fact that we don't give our email and other communications as much thought as we should. But I also think technology will actually get rid of this incivility problem. When you've got AVO and rating systems and social media posts and the ProNet recommendations, there's instantaneous feedback from our clients. Are you serving us or not? And they're not going to put up, they clearly are not putting up with these kinds of things. So I think technology is actually going to facilitate more civility and collaboration. I also think that the traditional bar, I'm excluding the people at the Clio conference, because I think you see that there's no point in lamenting the piece of the pie that internet providers or others have taken from traditional legal services. We don't want to do that stuff anyway. Remember sitting in a dusty warehouse going through documents? The routine tasks that are better accomplished through technology are not what's going to make us feel, wow, what a great contribution we had. So let it go. Let's focus on expanding the pie for everyone else. Comment 6 to your preamble to the model rules lays out all of these kinds of aspirational goals, which means improving access to justice, improving the quality of legal services, etc. And when we focus on that, we will also reap greater rewards. Another aspect of promoting professionalism, explicitly in Illinois, but also in other states, is to work to promote increased diversity and inclusion in our profession. You saw in a prior slide that 51% of the respondents in the statewide survey said incivility and unprofessionalism discourage diversity. I'm not sure what that is, whether women generally don't like the head-to-head conflict or whatever, but it is clear, we have enough research to support that better decision-making results from involving diverse viewpoints. And we as a profession need that diversity of viewpoints. If we're going to promote justice for all, we need to look like justice for all. We need to have women and minorities part of the process. Otherwise, it's pretty hypocritical. And even looking around at this conference, we have a ways to go to get to the diversity and inclusion that reflects the people we're serving in our country and in the world. But in the country right now, the last census shows that Caucasians are rapidly becoming more and more and more of a minority. And so we need to focus on that. Again, I think technology is a big plus in this regard. Technology is a bit of an equalizer, right? If you are a solo or a small firm person, you don't have to wait until you make your way up to the corner office, because you have at your disposal resources that 15, 20 years ago were only available to usually the men in the corner offices. But now, smaller organizations can compete through technology. You have the ability to play with the big boys and get the clients, etc. So I think that diversity is something we need to focus on as a profession, and we have a ways to go. Even though women have been graduating, for at least 2 decades at 50% from law schools, they're not in leadership positions. 15 to 17% of the equity partners in AmLaw 200, and very, very small minorities of any sort of management committees across law firms generally. So how do we wrap our arms around these professionalism principles and carry them forward to the next generation, assuming that we think it's valuable? I think it is. I think mentoring has been mentioned by several of the speakers, including John Suck. We need to focus on the soft skills, because that's going to be our value add to our clients. And those are not being taught in law schools. I'm not sure those can be taught in any sort of school setting. But when a younger associate or lawyer comes to you and says, I don't know how to handle, X situation, usually you ask a bunch of questions, right? Let's say it's, I don't know how to handle a prickly client or crabby judge or whatever. You say, well, it depends. What's your relationship? How long have you known this person? What's been the course of interactions? What's the matter? What have you tried? What has the result been? So a seasoned and experienced lawyer can help bring along the next generation. And that's exceedingly important because the pressures on law firms and organizations means that they don't have as much formal mentoring going on inside the firms. And clients no longer, as they were 20, 30 years ago, are willing to pay for the second and third chairs and shadowing. That was the way a lot of us learned how to practice law. In Illinois and in many other states over the last decade, there seems to be a resurgence of formal mentoring programs. We have a statewide program that's 4 years old now, and the survey results show 98%, both the mentees and the mentors rate it as a highly valuable experience. They each get CLE credit, that helps, but more importantly, they say, we will keep the relationship going after this year. That's a good thing. To our surprise and delight, the mentors seem to be even more ecstatic than the mentees, because I think they didn't expect to get anything back. They thought they would just be giving. But the comments show stuff like, I'm reinvigorated. It's great to be around somebody who's so optimistic and beginning their career. And I felt such gratification about being able to help, those kinds of things. So mentoring is a great thing. So at the end of the day, What our impact is as lawyers will boil down to our professionalism, how we affect our clients personally. Now, the document production, the document automated systems are all very important to being more efficient. But the professionalism considerations at the end of the day, the service and the public understanding and access to justice are extremely important. We are the only profession that is obliged by our rules to serve pro bono publico, meaning in the public good. This doesn't mean you get a deadbeat client you don't collect. This means that you go out of your way to render services for which no compensation is expected. It's kind of a burden. On the other hand, it's what makes us feel, yeah, this is why I went to law school. There's a lot of research about volunteerism and giving back and the physiological and psychological benefits. So in that sense, we're kind of lucky that our profession is exhorting us to do something that will make us feel good and provide benefits to us as well. The last consideration I want to emphasize about professionalism is educating the public. In the preamble, it says that lawyers have an obligation to provide education beyond just to their clients. And they're obliged to use their legal knowledge to improve the legal education, to reform the law, and aid the public's understanding about the administration of justice. Aid the public's understanding about the administration of justice. Why? Well, I couldn't say it any better. It says this in the preamble. Legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. Well, I'm thinking about the events of Ferguson and New York and Baltimore over the last, say, year, 18 months. I'd say we don't have a lot of popular participation or support in our legal institutions. And so the very foundation of our system is under siege. And so we need to refocus our effort on that. And I know it's hard when you're practicing law, but there are organizations that are doing that. We need to tell people why are we relevant, and we need to show them why we're relevant. We have the best system in the world. It's not perfect, but it depends on the involvement of lawyers to maintain its integrity. So that's why it's important to have professionalism. I'm just going to wind this up and we can have some questions if you want. It's a challenge because we're trained to look in our rearview mirrors, right? Several speakers talked about the fact that we revere precedent, we don't step beyond precedent, and we minimize risk. So looking backwards doesn't really help us in this world. So we need to embrace the new world and the possibilities that technology and new models can provide to our society and bring along the values so that we can keep our society so great as it is. Because I do think, if you look at lawyers, we are involved in every change that makes our society so great to live in. And we need to remember that and connect to that, the higher aspirations of why we're lawyers and what we can contribute to society. So that's why professionalism is key to remember, despite and because of all the changes that we're having now. So thank you very much for your attention. If you have any questions, I'd be happy to answer them.